This plaintiff state petition. The petitioner has filed a suit.
1 minute,
Please.
Yes,
The suit is filed for a declaration that he has a right of easement in respect of a way which is shown in B schedule of the plaint. The subject matter of the land which was allotted to him was in a partition between himself and defendants.
you are the plaintiff.
I'm the plaintiff. Now, the facts are not in dispute with regard to the partition and the property being allotted to me. Now, what is in dispute is, if I can take your lordship to the hand sketch which is produced in the plaint, page number 80, let's.
So what is the order now?
Now, the order is, an injunction was granted in my favor and an application filed in a suit. That is reversed by the appellate court, holding that since the recitals in the partition deed doesn't give a right of way to me to approach my property, hence an injunction that was granted by the trial court is,
Let us see that order.
yes. Let the original order pass.
Let's see 57.
Very good.
Where is the reasoning?
Well, the reasons starts at page number 65.
Yes, 65.
Yes.
Please read.
Yeah, para 15 minutes. Para 15 onwards. Before that, the contentions are.
It will be easy for me to understand the facts.
Yes, very good. The 2 points are interconnected to each other. Hence, I would like to take up these 2 points together at one stretch to avoid repetition of facts and confusion. The plaintiff's taken contention that he has filed a suit against the defendants for the relief of right of easement and also permanent injunction in respect of the suit Schedule B property. Further contended that the properties belonging to family were divided between the plaintiffs and defendants. Further submits that there is no road access to the plaintiff's property, which was fallen to his share apart from the property of the defendants.
The plaintiff and the defendants are family members.
Yes. Hence, there is no alternative way to reach his land. Hence, plaintiff has filed a suit for seeking necessary reliefs and also maintained an application under Order 39-1 and 2 of CPC, restraining the defendants from interfering with the peaceful possession and enjoyment of the scheduled property. To support of the case of the plaintiff, he has filed the registered partition deed affected among the family members of the plaintiff on 24/12/2019. I have perused the same, wherein the suit Schedule B properties were fallen to the share of defendant, and the land bearing survey number 953/G, measuring 3 acres 3.51 acres, was fallen to the share of plaintiff's father. But I have carefully perused the said document, wherein there is no recital regarding there is no way in the suit Schedule B property to reach the land of the plaintiffs bearing survey number 953G. He has also produced one more document, that is gift deed executed by KG Karibasamma, wife of so and so, KG Mahalingan Gowda, in favor of KG Siddhan Gowda, that is plaintiff, in the suit before the learned trial court. Even in the said document, there is no recital regarding there is a way in the suit Schedule B property to reach the land of the plaintiff bearing survey number 953/G, and also furnished a copy of the village map of Hosaldi Gram village. I have also produced the same, wherein there is no mention about the way in the suit Schedule B property to reach the land of the plaintiff bearing survey number 953/G. He also produced a letter to DC, ADLR, CO and PDO, Hosaldi Gram Panchayat, regarding the defendants are not permitting them to proceed with the suit Schedule property to the land bearing survey number 953G, and also furnishing RTCs which are clearly shows that suit Schedule property stands in the name of defendant number 1 and the land bearing survey number 953G stands in the name of plaintiff. Further, he has also furnished the copy of the conversion order passed by the learned Deputy Commissioner Vijayanagara in respect of the suit Schedule B property, and also furnished the copies of the plan approved by the City and Rural Planning Department and the copy of the resolution of Taluk Panchayat regarding formation of sites. The defendants have taken contention that there is a national highway which is connected to the plaintiff's property. On the basis of registered partition dated 24/12/2019, the defendant number 1 is the absolute owner and in possession of suit Schedule B property. But in the partition deed, there is no recital showing that there exists a way to reach the plaintiff's property through the suit Schedule B property. Furthermore, the defendant number 1 submits that he has developed suit Schedule B property and obtained the orders from the Deputy Commissioner Vijayanagar district about conversion order from agriculture to non-agriculture purpose. As per the approved plan by the Town and Rural Planning Department, it clearly shows that defendant number 1 has formed a road at the time of formation of sites in the suit Schedule B property. Hence, the plaintiff has failed to establish that there is no alternative way to reach the land of the plaintiff. As such, he cannot seek the relief of declaration in respect of the suit Schedule B property, and also cannot seek the relief of permanent injunction in respect of suit Schedule B property. Hence, application may be dismissed with cause. To establish the case of the defendant number 1, he has produced a copy of the conversion order passed by the learned Deputy Commissioner Vijayanagara in respect of suit Schedule B property, and also furnished the copies of the plan approved by the City and Rural Planning Department and the copy of the resolution of Taluk Panchayat regarding formation of site, and also copy of the resolutions passed by the Hosaldi Gram Panchayat regarding registration of sites and village map. On perusal of the IA along with the affidavit, objections filed by the defendant, and also documents available on record, which are clearly shows that plaintiff has filed the suit against the defendants for relief of easementary and also the permanent injunction in respect of suit schedule B property, and also furnished one hand sketch along with the plaint.
Now please come to the order passed in the suit,
In the suit, very,
page number.
my lords will get it at page number, it starts at page 35, the reasons at page number 40 minutes.
In this order, come to the, it's a short order, we'll read from 7.
Yes. I've taken these points together, Lord. Yes. I have taken these points together as these points are connected to each other and also to avoid repetition of facts. The present suit is filed by the plaintiff seeking the relief of declaration and permanent injunction against the defendants. The defendants have filed written statement and contended that the suit shell property is in their possession and there is no road as stated in the plaint. The plaintiff states that the properties belonging to the family were divided between the plaintiffs and defendants. The plaintiff's case is that there is no road access to the plaintiff's property, which was fallen to his share apart from the property belonging to the defendants. On the other hand, defendants said that there is a national highway which is connecting to the plaintiff's property. Perusal of the partition deed, the plaintiffs and defendants who are the family members show that with respect to property fallen to the share of family members, there is no boundaries mentioned. The present suit is filed on 15/9/2023. The plaintiff has produced a gift deed dated 31/10/2022, under which he has received the suit property through a gift deed. The perusal of the same shows that with respect to the suit schedule property, there is no road. The plaintiff has produced a village map with respect to the suit schedule property, which shows that there is no road seen with respect to the suit schedule property. On the other hand, defendants have produced a relinquishment deed under which defendant number 1 has released the rights with respect to some portion of 953/A/2 and 954/A/3B for the purpose of road. Defendant number 1 has also produced a conversion order with respect to 953/A/2 and 954/A/3B, on which the said properties measuring 1 acre 31 cents and 60 cents are converted for non-agricultural purpose. From the perusal of the documents produced by the defendant number 1, it is clear that there is a layout formed in 953/A/2 and 954/A/3B. The defendant states that the plaintiff has produced wrong sketch. However, from the prima facie perusal of the materials available on the file.
So the reason for the court to give the interim order is that there is no material to show. You
Yes.
have an alternative way
Yes.
to reach the land.
Yes.
The appellate court gives a finding that there is an alternative way
Yes.
to reach your land.
Yes.
That's how it is denied.
Yes.
So what is, what is the loss that is going to be caused to you pending consideration of the?
No, there is no road. That's the only reason why I'm before this court. If I can take your lordships to the documents which have been filed by them, there are two grounds on which they are opposing my claim.
Let's forget about their grounds. Please
Yes.
come to the findings of the appellate court.
Yes,
Where there is a finding with regard to the alternative way. Whether that is correct or not, you have to tell the court.
please. Your lordships, page number 70 minutes,
Yes, please.
from line number 2.
Yes.
As per the documents submitted by defendant number 1, which are clearly shows that there is an alternative way to reach the plaintiff's property from national highway.
Yes. Do you deny this?
Yes, ma'am. I have produced the village map also, that after my property, there is one more land.
What is this document by the defendant number 1 which shows that there is an alternative way?
They rely, they made,
Document?
Please,
What is the document?
it's annexure, my lord, so R5, my lord, your lordships.
it's a
Along with the,
sketch that is
along
prepared.
with the,
It is a sketch that is prepared. He has produced it along with the application here, prepared by themselves without being certified anyone. He lives on property which is behind my property. Thereafter, there is a national highway. I have produced a village map also.
No, let us see the document which relied on by him.
The
before
document
court.
which the court looks into is, the document which my learned friend has produced is at annexure,
Page number?
page number 51 minutes along with the application
Page
for vacating
number
stay.
51 along with this.
Along with the application for vacating stay which he has filed.
Let's see. What is this document?
Well, this is a sketch that is prepared by them to show that 953 is my land, 953 is my lots on the bottom of that. At page
Are you
31,
referring to 51?
page 31 of the application blades for vacating stay. Yes,
31.
yes. Sorry, I'm sorry. It's 51. It's written as 31. My apology.
49 is the, my lords, approved.
This is Gram Panchayat Karyalayam.
Gram Panchayat. 51 is a sketch which they have led, the sketch that is been prepared by them.
to know what is there before me is this, some proceedings of the Nagara something,
Minutes,
Grama.
my learned friend has given page 51 is there.
But the
This is
sketch,
51.
the approved
The
sketch
sketch,
is at
Milord,
page
is-
49 minutes, approved sketch. The proceedings are in respect of minutes, the granting of,
Some
No,
Gram
you're-
Panchayat,
yes, the approval,
proceedings.
yes, minutes, approval of the
Two
sketch.
pages
minutes,
thereafter, there is a sketch.
Page 49.
Now,
minutes,
the reason is based on this document.
48,
That is,
49 and 51.
I'll just pass on whatever
That
is
is in
given.
59, one sketch is there at 59.
59.
Go
not
to
okay.
him, these documents.
So this is what is furnished. The lords are referring to my documents probably.
ನಿಮ್ದು sir. Along with vacating stay. Vacating stage jota ಇದೆ. No, it is with the minutes. What your lordship are saying is not their records, minutes, along with the petition,
No,
along with the
after that I
vacate.
have seen. There are,
Those are the documents which I have. felt
They have
were
produced,
part-
minutes, yes.
ಇದೆ.
This is on the basis of the approved layout minutes that is being prepared.
This is a self-serving testimony minutes of that person. If my lords were to see down the bottom,
no,
the-
where from, what is the sketch? Where from you get it? Who has prepared it?
Previous minutes, 2 pages minutes, what I've stated in my vacating stay application, on the basis of these 2 documents, we have produced it for the convenience of the court. Just to show that there is a layout, there are 3 ways minutes. Page 48, if a lordship would see minutes, this is their land. This is the layout approved minutes. It is approved by the authority. 3 ways are there. Last way minutes, it reaches their land. Here minutes, there is a highway. For that minutes, we have showed page 51 as a document that there is also alternate road of highway. There 3 roads are already available. I undertake.
No, he denies that there is a way. Who has, if it is prepared by some officials of the department, we can understand. That's prepared by you. Why should the court consider this document?
No, if lordship would not consider this minutes, if lordship would consider the approved layout map,
Where is that?
that.
page
that
48
will-
and 51. minutes.
That he produces, if your lordship sees.
50.
Yes, 48 and 50, 49 are both minutes approved sketch
That's-
minutes by the authority.
Hmm.
Before
But
minutes
there your lordship
48.
would see 3 ways minutes. 3 ways are there to enter these.
You are referring to 48.
Yes, not 48. Your lordship would see the layout map. There is one 9 meters road and there are cross roads where 9 meters roads are left out nuts. There is 30 feet nuts. The last road nuts reaches his side. It is for his benefit also. In addition to this, what we have showed before the court and lordship for convenience, that there is a highway here that is being highway. They can't show it nuts in the layout approved site. But however, there is an alternate road here. We undertake 30 feet. They are asking for 12 feet or no, 30 feet road minutes. We lay the road for them. This already sites have been approved by the authority. Will not disturb his access to his land from this as per this layout. And this is approved. They have not challenged it. These documents have been referred by the
I'll
court.
answer to that. The lords may kindly take page 49. There are 2 plans they have produced. 49 doesn't show my property comes after his property. Now to show that I have access from this layout, your lordship shall kindly see how the mischief that is done first time before this honorable court is. Page 49 is approved plan, according to them is a modified plan. Your lords may kindly see the date there. It bears a date 26/7/2023. Lord, my property is not shown here. No national highway is shown. Now 48 is the very same document, the very same date saying that they have modified it. A modification has to be done either after a day after thereafter. Both bears the same date. And in page number 48, my property is shown in a handwritten. Only for the purpose of this petition to ensure that the injunction is vacated. Now 953G is written in hand billets. If it was modified, if everything was written billets done by the authorities, then only my property number should not have been written in hand. And both billets orders,
Oh, pending consideration of the suit. If the petition is permitted to use the way, what will happen?
No, that is what I am saying. But the way which we have shown in the layout.
As per the order that is passed by the trial court.
No, that there is no material milots that there is a road. If there is a material milots, I don't have any objection. There is no way there milots. Even as per their sketch, which they have shown for their purpose, but it comes here only milots. The property 953G. But in the said layout milots, what they have shown is Marpadita Vasati Vinyasa modified to show their land milots.
He has mentioned a particular measurement or the survey number.
Yes.
Whatever it is. Now, what is there in existence in that?
In existence of their property.
He is seeking right of declaration of easement, isn't it?
Please.
By necessity, yes.
He has mentioned some, according to you, is what purpose or how you are using that property?
They
So
have
we have
converted.
laid, we have laid sites approved before they file suit, this is being done. After all this, after laying all the sites, and roads, now they are saying that we used to use this road, we want this road, which comes, this way. But what we are saying is we are laying road for them, 30 feet road is available, they can use this, it's convenient for them.
How do we ascertain this fact?
No, they can't, if they dispute, what I'm saying is not,
They're disputing there is a road. You're saying there is a,
no, what they are saying is they're disputing now this portion that it is not there in the earlier layout map. Not here, they have said that it is modified.
put a quieters to
Please.
both your rival contentions. What is to be done?
Not what I'm saying is the layout is already approved, they have not challenged it, but I'll allow them not this way. But they want to go this way, when I'm saying there is already road, you can take vehicle, tractors.
But that, shall I record that the respondent, defendant undertakes to provide an alternative road to the petitioner?
But definitely, that is what I'm saying. I undertake that they can pass through this, either of the three roads.
Pending
When-
disposal, pending disposal.
Pending, yes,
of the-
pending disposal.
Disposal of the suit. If they say that they are going to provide an alternative road, then no prejudice. to
I
you.
cannot have any objection, provided that what happens is this. Certainly it will be inure to my benefit, because I only want to reach my road, whether it is from this side or that side doesn't make any difference. But the problem is, to reach my property, I have to cross his property.
We'll not go into all those issues.
Yes.
You want an ingress and egress. to
Yes,
the
ma'am.
property. If they are provided, we'll say that that's a responsibility of the undertakes,
Please,
that
please.
they will provide it.
Please.
Then whether you have an existing road as you want, it will be decided in the suit. The present petition is filed.
Only one clarification, not in terms of what they are now trying to project before your lordships based on this.
We are not making any.
Yes, yes.
Any kind of
Yes,
observation
yes.
on the merits of the matter.
Please,
Now pending disposal of the case and when an IA has to be decided. With
Certainly.
regard to we are only for the limited purpose of your convenience to reach the property is taken into consideration without even going into the merits of the matter, whether your contentions are right or whether.
Yes,
the
yes,
findings of
that
the
has to be
appellate court
adjudged.
are right. We are not
We will
going
provide
into
them
that.
alternative.
The
Yes,
only thing is, what you require pending suitors, you need to weigh.
please.
That
Please.
will be provided by the defendant.
Yes.
And all contentions are left open to be
Please.
decided by the trial court.
please. And this interim arrangement would be subject to, will have no.
No bearing.
Yes.
That I-
Tomorrow they should not say, I have agreed.
No, but please listen to the order, then you will
Yes.
understand. The agreed by the orders passed in MA number 6 of 2025, dated 14 November 2025. The petitioner plaintiff is before this court. The plaintiff had filed a suit seeking declaration that
Declaration that he has a right of easement over the suit.
seeking declaration that he has a right of easement in respect of the sue scheduled property. Along with the suit, he has filed an IA seeking injunction. The court by that's IA number,
1 minute.
I number 2, I think.
Two.
I number
I'm
two.
sorry. I number 2 minutes.
IA number 2 is filed under order 39.